Courts are reluctant to set aside the contract between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to extract agreement, and in certain circumstances, courts will set aside apparent contracts. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law were slower to develop a response to the use of illegitimate pressure, but do now recognize, under the doctrine of duress, to render a contract voidable where one party has employed illegitimate pressure during the contractual process. Initially, only duress to the person was recognized as duress. This means a threat to the personal security of an individual, as in Barton v. Armstrong in 1976. Gradually, the law developed to encompass duress to goods, and more recently, economic duress. There is some support for the position that duress renders a contract void amongst the academic commentators. The better view, however, is that duress renders a contract voidable rather than void. The apparent consent of the victimized party is treated as revocable. They have the ability to affirm or not affirm the contract. If they choose not to affirm the contract is void. See Universe Tankships of Monrovia versus International Transport Workers Federation in 1983 and Pao On versus Lao Yu Long from 1980. The effect of finding that duress renders a contract voidable creates several important consequences. These are that the party subject to the duress must act promptly to set aside the contract. See North Ocean Shipping vs. Hyundai Construction from 1979. And the third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by duress. The effect of finding that duress renders a contract voidable creates several important consequences. These are that the party subject to the duress must act promptly to set aside the contract. See North Ocean Shipping vs. Hyundai from 1979. And the third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by duress. Duress to the person occurs when one party to a contract forces another to contract with him through threats of violence. Where a party enters into a contract for several reasons, of which the duress is only one reason, the contract is still voidable. See Barton v. Armstrong from 1976. Duress to goods may occur where one person threatens to destroy or take the goods of another unless a contract is entered into. Duress to goods was recognized in the case of the Cibo N and the Cibo 3 from 1976. Economic duress, as such, was recognized in Pao On vs. Lao Yu Long from 1980 and Universe Tankships of Monrovia in 1983. Economic duress occurs when one party uses its superior economic power to force the weaker party into an agreement. The main difficulty in this area is to draw a line between unacceptable commercial pressures, which amount to economic duress, and acceptable commercial pressures which do not amount to economic duress. Duress exists when there is an illegitimate threat to perform an act unless the other party enters into a contract or varies an existing contract. Consent must be vitiated. Lord Hoffman in R vs. Attorney General from 2003 stated that the wrong of duress had two elements. First, pressure amounting to compulsion of the will of the victim, and the second was the illegitimacy of the pressure. The difference between acceptable and unacceptable commercial pressures is explained in the speech of Lord Scarman in Pao On vs. Lao Yu Long from 1980. The following are used in determining whether or not there was a coercion of the will, such as to vitiate consent. One has to ask the following questions. Did the person who was allegedly coerced protest at the time? Did this person have an alternative course of action open to him, such as adequate legal remedy? Was the person independently advised? And finally, did the person take steps to avoid the contract once they had entered it? See CTN Kashenkari vs. Gallagher from 1994. While the common law doctrine of duress is concerned with the procedure by which a contract has been agreed, the equitable doctrine of undue influence is focused upon the relationship between the parties. Equity acts upon the conscience, and the equitable doctrine of undue influence operates where the people are in a relationship where one party relies on the other. The court in Royal Bank of Scotland v. Ettridge, 2001, described undue influence as one of the grounds of relief developed by the courts of equity as a court of conscience. The objective is to ensure that the influence of one person over another is not abused. In the past, courts divided undue influence into two categories: actual undue influence and presumed undue influence. Royal Bank of Scotland v. Ettridge re-explained what was meant by this division. In one instance, undue influence was presumed as a matter of law by reason of the type of relationship between the parties. In the other instance, undue influence would not be presumed by law, but it was open to a party to establish an evidentiary presumption of undue influence. Actual undue influence. In such cases, the claimant must prove that the wrongdoer actually exerted an undue influence upon the complainant to enter into the transaction in question. In these instances, the criteria are that the party to the transaction, or the person who induced a transaction for his benefit, had the capacity to influence the other party. Secondly, that he did influence the other party. Thirdly, that the exercise of this influence was undue. And fourthly, that it was because of this influence that the transaction was brought about. In a situation of actual undue influence, it is not necessary to show that the transaction was manifestly disadvantageous to the party subject to the undue influence. See Lloyds Bank v. Bundy from 1975 and CIB Mortgages v. Pitt from 1993. Presumed undue influence. Here the claimant need not prove that there was actual undue influence. These situations, according to Lord Nichols in Royal Bank of Scotland v. Ettridge from 2001, may arise in one of two ways. In the first case, the law makes a genuine presumption in relation to certain defined types of relationships, such as doctor and patient, solicitor and client, trustee and beneficiary, religious advisor and disciple. In the second case, there is a shift in the evidential burden of proof from the complainant to the other party to show that the transaction was made without improper influence. For this situation to arise, two elements are required. Firstly, that the complainant reposed trust and confidence in the other party, or that the other party required ascendancy over the complainant. Secondly, that the transaction is not readily explicable other than as resulting from undue influence. The complainant may prove the de facto existence of a relationship under which the complainant generally reposed trust and confidence in the wrongdoer. The existence of such a relationship raises the presumption of undue influence. See Barclays Bank v. O'Brien from 1994. The burden of proof then shifts to the putative wrongdoer to disprove that they did not exercise undue influence, which is done by establishing that the complainant acted independently and understood his or her actions. Undue influence in third parties. The intervention of a third party gives rise to difficulties. In practice, most litigation occurs where the relationship of undue influence arises between A and B, whereby B enters into a contract with C for the benefit of A. The most common instance of this scenario is when the relationship of undue influence exists between spouses and one spouse induces the other to enter into a transaction with a bank. The most common way in which the bank can rebut the possibility of undue influence is by notice, meaning to inform the spouse as to the nature of the transaction and advise them to seek legal advice. See Barclays Bank v. O'Brien from 1993.